Hey there, estate planning attorney Paul Rabalais here, and in this video, I'm going to tell you 4 probate mistakes. And you know what? I'm going to throw in a bonus. Let's make it 5. All right, so there's a lot of people out there that have their probate horror story, their bad probate story. So I'm going to share some of the mistakes that are commonly made that cause families to result in these probate horror stories. So maybe if you're involved in one, you can take advantage of the education here and eliminate these common mistakes. So probate mistake number 1 is waiting too long. A lot of people say, you know what, we have to do mama's probate. Let's wait until the state gets us the death certificates, and then we'll call and schedule a meeting with the lawyer and start the probate process. Well, sometimes waiting on those death certificates, it's at least likely to take weeks, if not months. In fact, I'm gonna point you to right up there another video I did that at least is applicable for probates in Louisiana that talked about how you don't need death certificates to start a probate. So really a probate, and I've handled some where we got things done the day after somebody died. And so if you wait 6 or 8 weeks, then that pushes things back even farther. In fact, with the probate, there's multiple steps involved. And when one step is delayed, it just, it causes things to be delayed so much more on the back end, because you have to deal with the lawyer, then you've got to go deal with the financial institution, then you've got to go back and deal with the lawyer, then you got to go to the accountant, then you got to wait on a court order to be signed and processed, and then you got to go back to the financial institution, then back to the lawyer. And if you delay in any one of those multiple steps, that just throws the completion of it even much further down the road. And one of the biggest complaints that lawyers and others get about probate is why does it taken so long? And so the earlier you can get started and the more on top of things you can stay, it's much less likely that you'll wind up with one of those probate horror stories. Mistake number 2, hiring the wrong lawyer. Not to toot my own horn or anything like that, but just that's a mistake that some families make when they're dealing with the probate. Don't be one of those people who said, you know what, it took the lawyer forever just to do anything. And you see that a lot because often in probate, there's no deadline. And then you work with a lawyer, and yes, they're handling your probate, but they're also handling maybe other matters, other car wreck lawsuits or divorces or something that they've got to handle at the courthouse. And there are deadlines on those other matters. And so since there aren't deadlines in a probate and there are deadlines on other legal matters that the lawyer may be handling, guess which ones get the attention? The ones that have a deadline. So sometimes these things sit and sit. You need to work with a lawyer who's going to make sure there's no delay. Maybe don't be the person who says, you know what, we worked with this lawyer and I don't really think he knew what he was doing. Or I think the lawyer was in over his head. Or don't be the one that says, we use this lawyer because they're a friend of the family. The right lawyer that helps you is going to be the one with an excellent working knowledge of all of the subject matter, is going to be prompt, going to clearly communicate in easy, understandable terms what's going on and what the steps are to completion. And then also one that uses, these days technology where appropriate to expedite things. The wrong lawyer is going to be unresponsive, unsure of what to do, don't get a good feel or vibe about it when you talk to them. And here's the deal. You probably only have one chance to get it right. So if you don't get that good feel or vibe from the get-go, stop that right in its tracks and go elsewhere. So probate mistake number 2 is hiring the wrong lawyer. Probate mistake number 3, and this is the biggest mistake that causes the most problems, and you'll probably understand why as I get through it. Failing to communicate openly. I'll start by saying, I think it was dear Abby who said, if you really want to get to know somebody, share an inheritance with them. Now, completing a probate requires the cooperation of all of the heirs. Doesn't require the cooperation of 3 of the 4 heirs or 2 of the 3 heirs. To complete a probate, it requires the cooperation of all of the heirs, even the ones you don't like or the ones who don't like you. And if you fail to communicate with them, they're going to like you less. So what you need to do, especially if you're in charge and there's participants out there that you don't have a very good relationship, or maybe you have an awful relationship with them, I think you need to swallow your pride, and I think you need to make it a goal or a challenge to openly and transparently communicate with all of the heirs. And so what I mean by that is, even if you don't want to talk to them or you don't want to see them, then here's what you do. Get all of the email addresses of all of the participants, and then just send out a number of at different times, these group email messages where you communicate, with scans and with emails, a copy of the will, a list of all of the assets and debts, any kind of plan you have on administering the assets. If perhaps you have a plan to sell the house or to sell the vehicle if you're the executor or the administrator. And so let them know how everything's going to go. And also impose that requirement on that group email that if they have any questions or concerns, they are to click on the reply all button, so everybody sees the questions and concerns that are being posed, and everybody sees the answers to those questions or concerns that have been posed. And that way, nobody's having to answer questions multiple times, and there's not the, well, he said, you said that. No, it's all open and transparent. And then just update them of developments of the probate as they occur in that group email. So there's nothing worse as an heir than to have somebody that you don't like or trust being in charge of your inheritance, and they are refusing to communicate with you. You're asking for trouble. That's mistake number 3, failing to openly communicate. And mistake number 4 is, if you're in charge of the estate, failing to collect all of the estate's funds in an estate account. So here's the deal. Mama may have had bank accounts at 2 or 3 different banks. She had some checking, she had some savings, she had some CDs. So your job as the executor is to, once you get the appropriate court orders, open up an estate account at a bank and then pool all of Mama's money from all of her accounts, which you'll have the authority to do, into that estate account. And you can be smacked with a penalty or a fine for failing to do that. In fact, here in my state of Louisiana, a judge can render a judgment against you at 20% per year on the amount that wasn't deposited into the estate account. So if you played around with $500,000 and you did that for a year and you didn't collect that in the estate account, a judge can say, boom, you're fined $100,000, 20% of that $500,000 for failing to collect the funds in the estate account. So don't be that guy. So mistake number 5, my bonus mistake in making sure that probates go smooth. Big mistake number 5 is failing to smash the like button and subscribe to this channel and hit the notification bell so you don't miss anything. There you go, 5 probate mistakes. We'll see you next time.